Good morning, ladies and gentlemen. Welcome back to our series of tutorial and voiceover on mercantile law. We have covered different topics and stages of the tutorial, and now we go for presentment of negotiable instrument. A presentment means presentation of a negotiable instrument for acceptance, sight, or payment before the payer. Uh, Sight or payment before an acceptor, maker, drawee, or other party. The kinds of presentments are as follow. Number one, presentment of bill for acceptance. Number two, presentment of promissory note for sight. Number three, presentment of negotiable instrument for payment. Presentment for acceptance. The acceptance means acknowledgement of the sum mentioned in a bill by the drawee. The drawee is not liable unless the bill is presented to him for the acceptance. The drawee gives his consent by writing the word accepted and returns to the holder. The following bills need not to be presented for acceptance: a bill payable on demand, a bill payable on the expiry of certain period, that is, for example, 3 months, a bill payable on a fixed date, any date provided. However, the following bills must be presented for acceptance: a bill payable after sight must be presented to the drawee for acceptance to fix the maturity date. A bill containing an express condition that it must be presented for acceptance before payment. Essentials of a valid acceptance. There are essentials of a valid acceptance, such as it must be in writing, it must be signed by the drawee or his agent, it must appear on the bill, the accepted bill must be returned to the holder. Types of acceptance. There are various types, such as two types of acceptance. The first one is general acceptance, when the drawee accepts the liability to pay the full amount mentioned in the bill without any condition. The acceptance is called general or absolute. The acceptor may mention the bank where payment shall be made. Qualified acceptance. This is the second one, in fact. Qualified acceptance. When the drawee accepts the bill subject to some conditions, it is called a conditional or qualified acceptance. For example, acceptance for an amount less than that mentioned in the bill or for a longer period than specified in the bill. The holder may refuse to take a qualified acceptance or treat the bill as dishonored and sue the drawer. The holder may accept qualified acceptance. If he accepts such a qualified acceptance without the consent of the prior parties are discharged from their liability. Who may present it? Well, any one of the persons can accept it, the ones whom I mention here. The holder himself can present it. The authorized agent of the holder can present it. The endorsee, in case of an endorsement, can present it. Who may accept it? Earlier we were talking about the presentation, and now we're talking about the acceptance. Well, the drawer or his authorized agent can accept it. All the drawees, when there are several drawees, if some drawees are authorized to accept, then their acceptance is enough. The legal representatives, in case of a drawee is dead, they can accept it. The official receiver, in case of a drawee has become insolvent, he can accept it or she can accept it. The drawee, in case of a need, if the original drawee refuses to accept, can do it, can accept it. The acceptor for honor, that is, who accepts the bill for honor of any other party, can do it. Now we need to talk about the time of presentment. What is the time of presentment? This is what we will do in the next video. as we get along with it.